All right, good morning. Ana Gutierrez with Hogan Lovells out of our Denver office. I know I'm a lawyer, forgive me for that, but thank you for having me. And I just want to extend a thank you, like others, to Kirby for putting on this symposium. It's a really incredible event, and was just talking to a few folks during the break about how it just creates a good opportunity to have conversations that are perhaps more casual but really important to move things along, both from policy and I think there's a slide deck, sorry, if you're able to flip that up. Thank you. But I have 30 minutes to talk to you about changing state and federal oil and gas policies. This is a very, very busy time, so there is no way that I'm going to get through everything that's going on, and this is going to feel a little bit fast and furious, but I did select just a few of the more recent developments that I think are important for folks in local governments to recognize are either on the horizon or have just dropped, so that you can help your operators or help your communities in answering questions and understanding how to implement the various policy changes. So just as by way of quick intro, you'll see on the topics, this is sort of the list of what I'm gonna hit today. Like I said, so we had a little gap there. I was already gonna try and catch up some time, so this may be just a bit fast and furious. It's intended to be broad brush and high level, not a deep dive really on any of these given topics, but these are, again, what I think are important to know, important for local governments in particular to know as you move through this year. All right, so before I jump into those topics, I want to put this conversation in context because I think that's important. I've pulled some of the data from the U.S. Energy Information Administration. They published their 2023 annual energy outlook, and in short, the data and analysis are showing that oil and gas will continue to be a bedrock in the overall energy system in the United States and internationally. In fact, the EIA, it anticipates that oil and gas, both consumption and production, is anticipated either to hold steady or increase all the way out to 2050. So as we move through this energy transition, we'll see relative to 2022, there'll be an approximately 20 to 87%, which I know is a pretty big margin, but 20 to 87% increase of natural gas generating capacity through 2050. And we'll see in the U.S. that we'll continue to remain a net exporter of petroleum products, largely as a result of the high international demand. So with this trajectory in mind, I think it's really important to regulate and incentivize sustainable oil and gas in a balanced manner. This approach, it helps to displace production in other countries that may have far less stable or stringent environmental regulations and far less progressive policy goals. So let's jump right into recent developments at the Department of the Interior. So in 2021, and the commissioners in the room, this is a conversation with you guys, and I know we all need to continue talking after this one, but in 2021, the Department of the Interior asked BLM to increase its minimum bonding amounts, considering a variety of factors, right? New technologies, complexity of modern operations, what the current interest rates, inflation, all the different factors. And then in 2022, that directive was further emphasized by Senator Michael Bennet. We have not yet seen a proposed rule, but everybody that I continue to talk to at BLM on this topic said we should see it soon. It's expected soon. All right, so as you know, many of the operators in this room and your operators in your community, they've submitted updated financial assurance plans to COGCC, and a lot of those hearings will come through in May if a hearing is required. As a part of that rulemaking process, we exempted federal wells from COGCC's financial assurance program with the anticipation that BLM was going to and is in the process of updating its BLM bonding infrastructure. We still know that's coming, but as a part of the COGCC rule, we put a backstop to the duration in which federal wells are exempted from that program. So come October 15th of this year, operators in your communities will need to update their plans, their financial assurance plans that frankly they likely just submitted to COGCC, to include financial assurance for their federal wells. The key is for this financial assurance on those federal wells not to be duplicative, but need to be, the federal financial assurance coverage needs to be substantially equivalent to what the state expectation is. So I think there will be ongoing conversations amongst operators, with the commissioners in this room, with Director Murphy, on how we move through that sequence in the next few months anticipating that we likely won't see a final rule from BLM on this particular topic before October 15th. Okay, so this is still within the realm of the Interior. So less than a month ago, BLM issued a pre-publication version of a really interesting rule. It's a proposed rule to promote conservation on public lands. What's interesting about it is this rule would designate conservation as a term of art, as a form of land use on public lands. So when we think of land use on public lands, we think of recreation, we think of grazing, we think of energy development. This draft rule would propose that conservation is also a land use for public lands. It would then allow BLM to identify intact landscapes and formally place, quote, conservation leases on those landscapes. So these leases would then be available to private parties for purposes of conservations, and they're conceptually being treated similarly to an energy development lease in that they would have a duration of 10 years. Obviously, there would be terms and conditions and fees associated with it. And then I think the concept is also that these conservation leases could be used in the context of compensatory mitigation, right? If there's another project that may require compensatory mitigation for the projects that it is for which it's causing impacts, then this could be a component piece of addressing that mitigation. If that's the case, then that duration of that lease could be extended a bit longer. I think this one is particularly important because, as you know, Colorado's 8.3 million acres of lands and more than 27 million acres of mineral estate. It really supports diverse lifestyle, diverse communities, and diverse land uses. And so putting a conservation lease on that would then limit what could be done on that particular piece of property, which may or may not be, aligned with the multiple use mandate that is within the agency's realm. So this is the last piece from the Interior that I want to talk about, and it's the Orphan Well Grants Program. You did hear a little bit about it this morning from DNR and Director Gibbs. The bipartisan infrastructure law, it had significant funding for states and tribes to address plugging and abandonment of federal wells. The Department of the Interior is now in its first phase of implementing the formula funding. So Colorado has received that first tranche of the $24 million that Director Gibbs referenced, and then now we're moving through this phase of applying for a formula grant, if you will. Under this first phase, Colorado is eligible for $14 million in that grant funding, and it can be applied for now through August 31st. So folks at the Commission and Director Murphy may have updates for us on the application process or what additional funding might look like through this available resource, and the expectations around both what we might receive and how we would utilize those funds. What's important for you all, for local governments in particular, is the window for applying for these funds are open now. And while the funding is going to go to the state, I think it's important to be a part of that conversation with the state. As a formula fund, it requires the state identify, where are the needs, where's the energy employment, where's the energy production, where are the impacts, the taxes. And so local governments can help filter, collect, gather, and work with the state and COGCC to have that information at its fingertips in terms of applying for these funds and receiving it. And then, of course, it would be important to be a part of the conversation with respect to distribution of those resources for your particular communities. Let's touch on NEPA. I'm a nerd, so NEPA is one of my favorite statutes that exists. National Environmental Policy Act. So on January 9th, 2023, this year, CEQ published an interim guidance on how greenhouse gases should be considered under NEPA. At an extremely high level, I don't want to get us bogged down in the weeds of NEPA, but NEPA requires federal agencies to consider the environmental impacts before taking or authorizing a major federal action. Nearly every project that touches federal resources, both funding and or federal lands, requires NEPA at some level, whether that's a CADX, an environmental assessment, or an environmental impact statement. So although GHGs, greenhouse gas emissions, have been analyzed and discussed for years and years and years as a part of NEPA, the actual NEPA statute and supporting regulations don't specifically address how they should look at greenhouse gases and don't specifically identify that receptor. There is a long and battled history of regulatory guidance and litigation around this particular topic, and I'll leave that for another day. I think that's a 2-hour presentation on its own. But the key here is that the interim guidance, it intends to offer some clarity on what agencies should look at to satisfy their obligation to look at GHG impacts as a part of the NEPA analysis. The biggest shifts that you'll see in this interim guidance is that the document recommends that the agencies use the social cost of GHGs to contextualize impacts. Now, I think this is an important point because there's a parallel conversation entirely outside of this interim guidance regarding whether the social cost of GHGs is set at the right number, whether it's the appropriate metric, whether it is a tool we should be using in our regulatory landscape. So while there's that conversation, trying to understand what that social cost of GHGs does, how it's analyzed, what the impacts is, the agencies are being asked to use that as a metric when they do their NEPA analyses. The guidance also directs agencies to quantify emissions, both direct and indirect. This is going to be an extra lift for project proponents and the agencies that I don't think we've seen before. I recognize that as a part of the NEPA analyses, a lot of this has been done, but I don't think to the level of quantification that the interim guidance is asking for. So this is going to be a step up, if you will, on the analysis of GHG impacts from any particular project impacting federal lands. And then another, I think, interesting component is that it's asking agencies to consider the impacts of climate change on the proposed project. Right, so if a proposed project it needs water, for example, it is asking for that project, for that agency to have a look at, will climate change impact that water flow such that it will be an issue for that project to continue into the future. So they're trying to look at questions of resiliency around a proposed project as a result of climate change impacts. For this group, again, given the significance of federal lands in western Colorado, the recent updates are really important to track. The new guidance is really likely to impact each of these NEPA analyses that are required as a part of projects that are on federal lands, federal leases. And what's interesting is that NEPA it's a procedural statute, right? It doesn't dictate a specific outcome. But this interim guidance specifically says, or suggests at least, that the outcome should align with federal and state climate change commitments and goals. So I think there is some slant of direction in the interim guidance, and so I think it'll be interesting as we see each of the agencies interpret this and how it plays out. Colorado ozone SIP, fun stuff. This topic, just this past December, some of you local governments, operators certainly, and other stakeholders participated in the Air Quality Control Commission hearing where there were revisions adopted into our ozone SIP. For oil and gas, those revisions and new requirements are principally located in Regulation Number 7, and they took effect in February of this year. And I don't want to sit on the December rulemaking component of it because I think for this particular group, what's going to be more impactful is what's coming with respect to this process. That's because in the December 2022 rule, the Commission directed both the RAC and the Air Division to develop additional reduction measures or proposed reduction measures to attain our 2008 and 2015 NAAQS ozone standards. And so as a result of that, there was a list of concepts that should be evaluated, not necessarily proposed, but evaluated by both the RAC and the division as they're looking for opportunities to achieve these standards. This list is shown up here on your screen. It's obviously, there is a significant component and focus on upstream oil and gas production in particular and pre-production. So there's some in-depth conversations that are ongoing now. But the other piece I want to flag for this group and for local governments is it goes beyond that in particular, right? There are concepts related to lawn and garden, building efficiencies, commercial diesel best practices. So these are components that I think, as they're analyzed and if they land, will have a significant impact on your communities and something certainly to monitor, if not get yourselves involved in with both either the RAC or the division's processes as they move through this. So next I want to hit on EPA's, in the world of air, I want to hit on EPA's proposed methane emissions standards, the NSPS. In terms of the timeline, the draft rule was published in November of 2021. There was a huge slug of comments that were submitted, extremely technical, cost-effective analyses, trying to sort of parse through EPA's proposal. And then in December of 2022, to make things clearer than mud, EPA issued a supplement to the proposed rule. So now we have sort of a rule that was extremely dense, a revision to that rule that is supplemental with its own preamble and discussion. And we are expecting to see a final rule sometime this year. I've heard rumors of middle of the year, but not precisely sure when that will drop. It will be a really significant impact on the oil and gas industry. It's going to hit existing sources, new sources, and then there's a component of it that will put pressure or an obligation for states to update state implementation plans to make sure that they have regulations in place that match or as stringent as the federal program. So this list, I just want to throw it up here just so you see how comprehensive the NSPS is. The concept of NSPS is not new, but where they're going with this is honing in and diving more and more into control requirements, emission standards, emission thresholds that are just going to become significantly more stringent and potentially create some compliance challenges and questions as we move through implementation. One of the biggest changes I think is worth talking about that at least I for myself have continued to have questions on and am aiming to understand as this is both proposed and potentially implemented is that EPA had proposed what they called a super emitter response program. So under this program, a third party can use a remote sensing technology to identify a methane emissions at a particular facility. If it's identified over 100 kilograms per hour, they would report it to EPA or the delegated agency if they have that authority, and then that would trigger a process for the operator to take remedial action. I think this one is just important to be aware of in your communities because it's significant. It's creating sort of a third-party right to have a look or do some inspection, if you will, and it's going to create a lot of consternation, a lot of questions. I don't think we precisely know how it will be implemented, moderated, and move through that process. So I think, as I mentioned, this is not a rule that will be implemented by local governments, but it's worth flagging again because it's going to be incredibly impactful to the operators in your communities. I think it's just helpful to understand the scope and of the compliance obligations. So on the Inflation Reduction Act, in the theme of methane, I think it's also helpful to understand what that is doing. There's a lot of different component parts of the IRA that are going to be impactful to oil and gas operations across the nation and also in Colorado, including in Western Colorado. I just wanted to hone in on one that I think is particularly important to keep in mind. But the IRA added Section 136 to the Clean Air Act, and this essentially creates a new methane fee program. So it will assess a fee per ton on methane emissions over a certain intensity level. So you'll see those intensity levels are essentially your throughput over your emissions over throughput. Did I get that right, Angela? Whichever way it goes. And if you exceed that intensity, you are going to be taxed on the emissions that are coming out of your systems. And then the fees here are shown, which are not insignificant on a per ton basis. There is an opportunity for an operator to average these fees across their assets, right? So if you have one set of facilities that may be of ultra vintage, but you have a newer facility and that is going to be state of the art, you can average those intensities to perhaps lower your intensity. There's also an exemption if the facility is in compliance with the NSPS that we just talked about. I think there's going to be a host of questions around this and what qualifies as compliance at a facility when NSPS is really regulating equipment and components. I think that's a conversation for another day and one that we'll try to work through, but there's a bit of relief there if folks are maintaining their facilities in compliance with the national standards. So WOTUS, Waters of the U.S. I wanted to flag this for the Western Slope and Western region because I think there's a lot, there are a lot of waters of the U.S. that are impacted by the new rule that was recently finalized by both EPA and the Army Corps. And it was finalized just January of this year, and it took effect as recently as March 20th of last month. What it does is it aims to do so more clearly, waters of the U.S., which is perhaps one of the most contentious and litigated and very confusing definitions that exist out there in the legal realm. I'm not sure this creates a whole lot of clarity around the issue, but it intended to do so. So the new WOTUS rule, it clarifies the pre-2015 regulatory regime that had been in place since 1986, and then it aims to sort of put more scope and definition around it. So you'll see up there sort of the 7 component definitions of what are waters of the U.S. And then on that last bullet, where each of those are starred, it is aiming to define those particular components, the stream, for example, wetlands, as they have to have a significant nexus to one of the other defined terms in order to be determined to be a water of the U.S. So all very unclear, but can be very complicated. But on top of that, there's a Supreme Court decision that we're all waiting for, Sackett v. EPA. There, in that particular case, the Ninth Circuit applied the significant nexus test, but the question before the Supreme Court is, did they apply the right test? So we have this brand new rule that says, yep, significant nexus is the way to go. That's how you define WOTUS. And we're waiting for the Supreme Court to say go or no go, red or green. If we get red, I think EPA and Army Corps are back to the drawing board. There's a lot of litigation, right, because this definition significantly expands what was previously in place under the Trump administration. And so I think, we've seen the Texas v. EPA case, in West Virginia v. EPA, that's comprised of 24 state plaintiffs, and then a third case, Kentucky v. EPA. And this slide is really just for you guys to see, let's see what slide I'm on, 36. See the impact to Colorado, right? So this is from the amicus brief in the Sackett case, and this visual shows what intermittent streams would be considered waters of the U.S. and Colorado under the new definition. It's kind of impactful, right? So nearly every project that I think will happen in the state is going to require going through some conversation around permitting, whether that's a nationwide permit or what can be a really, really, really comprehensive and resource-intensive discussion around an individual permit, because an individual permit requires that the agency, the Army Corps, land on the least environmentally damaging practicable alternative. No other alternative can be approved, so it's quite the process to move through. All right, so there's a lot going on. Like I said, I only scratched the surface. This slide sort of piggybacks on Director Garcia from DOLA, his presentation on the funding opportunities. And I just throw this up here to supplement to say, there are a host of funding opportunities, both at the state and federal level, for local governments to apply for and receive funding to assist in implementation of the host of different policy and regulatory changes that are ongoing. So I would encourage you to take a closer look at this slide. I know Kirby's going to make them available, and see if that might be an opportunity to find resources to serve your communities. And with that, I will close out, and I'm happy to take questions.
Hello, how's it going? My name is Ethan Warwick from Colorado Mesa University. I'm a student here. I just have a quick question. Do you think responsible oil and gas regulation, like you talked about, would help the U.S. Avoid mistakes made by countries like Germany of pushing renewables too quickly?
It's a huge question.
Sorry.
Subtle. Where do I even begin? Simple answer, yes. Big answer, we are on an energy transition, and I think that's the right course to be on, but it has to happen balanced, right? It's not going to happen overnight, and natural gas and petroleum products are going to be a huge, huge, huge component part of a successful transition. And so absolutely, I think that we have to continue with responsible energy development on the oil and gas side of things to move through the process that is the policy agenda of the administrations.
Would those conservation leases be managed by the BLM or the lessee as no surface occupancy, including access by the public for recreation?
Yeah, great question. So I think they would be managed by BLM as I'm understanding it. It is still a proposed rule, so there's a lot of process around that and one that I think we should get involved in. But it would be, so typically, for example, if you have a grazing lease, it's a multiple use mandate, and recreation, for example, could happen on top of that grazing lease. You have all these different uses. But BLM in the proposed rule specifically said if it's a conservation easement or lease, they won't allow conflicting uses, if you will. So as I read that, a conservation easement and an energy development lease conflict. And so I think we would need to work through and step through that process and what that means and what kind of impacts that's going to have on all of this. Good question.
I thought I read somewhere that maybe to avoid all this plugging liability, especially in Denver, where you had oil and gas fields there before the people moved in,
Yep.
right? Many of the communities are encroaching in on existing oil and gas fields that have been there for 40 years. So is there some thought on the geothermal side to utilize those wells for geothermal, plug them back to a certain depth,
Yeah.
and then maybe circulate and utilize the heat from existing wells and reduce your plugging liability too?
Yeah, I've heard that conversation as well. I think not even just limited to geothermal though, right? I think storage or other opportunities or disposal, right? If a well can be safely repurposed for any of those reasons, I think folks are all on board, so we're not, scraping new territory, but using already impacted spaces. All right, thank you guys.